And good afternoon. I'm attorney Michael Bender.
And I'm attorney Allison Tilton, and we are the Gray Legal Group.
And welcome to take two of this week's Facebook Live of Ask a Lawyer. Before we begin, as always, the contents of this video is for general information purposes only. Nothing should be taken as legal advice on any individual case or situation. This information is not intended to create, and receipt or viewing does not constitute an attorney-client privilege. Well, this week we've
Relationship. No attorney-client
attorney-client
relationship.
Thank you.
You're welcome.
It is live. So, all right, we've got some questions this week on custody visitation. These are the hot topics that are constantly coming up, and a lot of stuff that we see quite often. So, do you want to go ahead and read the first question here?
Absolutely. So the first question reads, I have joint custody of a child who just started kindergarten. The father had the child for a week, and his wife, the child's stepmom, got transfer papers and transferred him to another school without my approval. Is this something that can legally, sorry, there's some words missing out of this question. Is this something that he can legally do?
Okay, well, I'll go ahead and tackle this one. It's back to school, and we get questions like this a lot. We see a lot of fighting about schools and where kids are going to be going to school. Can he legally do this? Quite frankly, no. If you have joint legal custody, that means both parents need to have an input on where the child is going to go to school. If a child is going to be transferred from one kindergarten to another, there needs to be a reason, there needs to be an agreement about that. It can't just be, well, this is the house that around the corner whenever he wants. But what you need to do is look at what your custody order says. Why you do have joint legal custody, what you probably have is a designation of a household, of a parent, for the purpose of school enrollment. So basically you might have joint legal, joint physical custody, but somebody's probably going to be designated as the primary custodial parent for school enrollment purposes, and that person's address, that house, is going to control where the child is enrolled. Now in this situation, if they've already gone ahead and transferred the child out of the school, options are to try and work it out with the father, try and get an agreement on where your son's going to go to school. Otherwise, this may be grounds for an emergency or an ex-parte hearing. Judges don't like when parents can't get along on school enrollment, so be very wary of filing that. But if nothing can be resolved and there is a significant disagreement on where the child's going to go to school, an ex-parte may be warranted. We'll move on to question number 2 here. This also is unfortunately, the underlying context here is something that we see a lot as well. Can I have visitation revoked? I have sole legal and sole physical custody of my 3-year-old son. His father is supposed to have visitation with my son every weekend. He does not see my child on his day, and when he does, he doesn't keep him as long as he's supposed to. When I allow him to see my son on other days, he keeps my son and brings him back late. We have a specific location to meet, and I often wait 30 minutes or more. When I deny him visitation on days he doesn't have, he sends me threatening texts saying he's going to take my son away or take me to court making false claims. Is there anything I can do?
So, excuse me, I apologize. Let me just say that prior to answering this question, I'm going to be the bad guy, and I'm going to reprimand the person that wrote this question. And the reason for this is that, as Michael read this, I counted mom using the word my 6 times. The courts, they don't want to hear parents referring to a child as my child. The child is both of your childs. You really need to refer to children as our children, or if you have to, refer to it as the child. But if you're in court and you're constantly referring to a child as yours, like a possession, that's going to greatly hurt your credibility in front of the judge. It's just viewed very terribly. Judges often reprimand parties for using the word my. So with that out of the way, let's get to part of this question. So the way I'm reading this is that father has visitation every weekend, and that's father's parenting time. He's awarded parenting time on the weekends. Whether or not father's going to exercise that parenting time, that's father's choice whether or not he's going to exercise that, but that is the time that he has. It appears that father is asking mom to accommodate his schedule and make the child available to him at other times other than what he's granted in his order. And quite frankly, he's not granted that time. So does mom need to accommodate dad's schedule? She doesn't. You don't have to. It's nice. There might be specific orders that say by mutual agreement of the parties. But quite frankly, if you don't have that time, it's not your time. With regards to a specific meeting location, that's often in an order, and that's often indicated, especially when there's parental conflict or the parents are living a distance apart, and it's really far to drive. It's really far to drive back and forth to both houses. But waiting 30 minutes or more. If that was during dad's designated times, I would say that you actually have some grounds to go back to court to modify your orders and essentially have dad reprimanded for the fact that he's making you wait. He's probably going to get penalized, but on these other days where you guys are agreeing to additional time, it would really be very specific to what the two of you are agreeing to. And for him to claim that you're denying him visitation when it's not his time, you're not denying him anything. You're accommodating his schedule. So I wouldn't be overly concerned with his threatening text messages saying that he's going to take you back to court. Both parents have the ability to go back to court at any time. But as Michael indicated in the first response, the court really wants the parents to work these things out outside of the court context. They want them to work things out together. But I wouldn't be overly concerned with him going back to court on this question.
If he does go back to court, you mentioned that there's threatening texts. Always save those texts. Those can definitely come in handy if the matter goes to a hearing or goes to a trial, being presented to a mediator or a judge. When parties don't get along like that, or somebody's threatening somebody else, they'll get reprimanded and truly see what their motives are here.
I think that about wraps that up.
All right. Well, thanks for joining us here on Ask a Lawyer this week. Join us every week as we discuss family law issues important to our community. If you have a legal question or topic you'd like us to address, go to thegraylegalgroup.com and click on Ask a Lawyer. We'll see you next week.